Dear Professor Dijak, ladies and gentlemen, thank you very much for your kind invitation here to come to Poznan and to talk to you. It's a great pleasure to be here with you today. In 1993, I published an essay on the European character of English law. I was arguing that it did not flourish in noble isolation from Europe, that there were historical links and intellectual influence. Right from the conquest, Anglo-Norman customary law was transplanted to England, down to the 19th century innovation in 19th century contract law, that's the famous A.W.B. Simpson article, or the German émigré scholars in the 20th century. Now, at that stage, I was focusing on the law of obligations. What about the law of succession? Now, one generally thinks that the law of succession is one of the most indigenous branches of the law, of private law, part of a country's cultural goods, part of a country's heritage, and less international in character. And if one looks from a continental perspective at English law, one often reads that there are fundamental differences. For instance, the indirect acquisition of the estate in England, the direct acquisition of the estate in Germany, and so on. I have written a paper. You've got this handout. I can't take you through all the details, but I'll take you in this lecture through the major points in that handout. And I want to start by stressing that there are three characteristic features of the English law of succession that have characteristically shaped it. One, the strict dividing line between real property and personal property. Two, the English law of succession evolved at the intersection between three different jurisdictions. The royal courts, responsible for the development of the common law, the ecclesiastical courts, responsible in all matters which concern the rule of souls. This is a quotation from the Ordinance of William the Conqueror. And then the Court of Chancery, supplementing both the common law and the ecclesiastical law. The third characteristic feature is the distinction between testamentary and intestate succession. That is something we all know. In England, one would talk of the law of wills and intestacy. Let me also mention at the outset that succession law in the continental tradition revolves around, it's slightly different in France, but in many continental systems, revolves around the person of the heir. The heir is a technical term, a central feature of many continental systems. Heir is not a technical term in England, as it is used today. It is a synonym for beneficiary. Now, for many centuries, heir in England has been a legally relevant term, but not in the comprehensive sense of the Roman heres, but just as a successor of the deceased as far as his real property was concerned. A number of canons of descent were developed, governing this part of the law. The preference of males over females, the preference of the oldest son over his younger brothers, the principle of representation, the parentalic system. That was one of the customs which had prevailed in England since the Norman conquest. It was based on the ancient principle of family succession and designed to prevent the fragmentation of the family estate. Testamentary dispositions concerning the real property were not permitted in England. This is a result of the famous ancient rule, solus Deus heredem facere pot est non homo. It's only God who can make an heir, not man by his will. Use of the term heir for the oldest son can still be found in 19th century literature. I mentioned just Anthony Trollope, Ralph the Heir. I recommend that is a novel for you to read. With all this, England was not alone. Otto von Gierke writes, for example, the distinction between movable and immovable property was as a profound opposition, rending asunder the law of property from its foundation to its rooftop and reaching over into the law of contract, family law, the law of succession, and the law of procedure was fundamental for the German tradition. As in England, we find in the old German law the principle of family succession. As in England, there was a bewildering multitude of customary laws, and as in England, as I've just said, the distinction between movable and immovable property was relevant and widely recognized. Also, the discrimination of women, primogeniture, the parentalic system, the principle of representation were accepted. I will now come to the rise of the will. The will, the testamentum, was one of the great achievements of Roman law. The renaissance of the will in the Middle Ages was due to the Church, because the Church essentially converted or understood, conceived of the will as a spiritual instrument, by means of which the testator could store up for himself treasures in heaven. Just think of St. Matthew 6, 19 and 20, where it says, "Lay not up for yourselves treasures upon earth, where moth and rust doth corrupt, and where thieves break through and steal. But lay up for yourselves treasures in heaven, where neither moth nor rust doth corrupt, and where thieves do not break through nor steal." So, therefore, dispositions ad pias causas were a common feature of medieval wills. The Corpus Juris Canonici reflected this, and it reflected the desire of the Church to save the will from invalidity for the benefit of the soul of the deceased. Therefore, we find a relaxation of the form requirements, no longer the 7 witnesses of Roman law, but the local priest and 2 suitable witnesses were sufficient to validate a will. There are other texts in the Corpus Juris Canonici which claimed a far-reaching competence of the Church and the Church courts in testamentary matters. Because, I repeat this, the will was conceived as a spiritual instrument, and that was particularly noticeable in England. We find this in William Lyndwood, the preeminent canonist of the 15th century, where he states the church courts are competent to confirm wills. This is what later on became called probate. The church courts determine the validity of a will, and we find the relaxation of the form requirements in Lyndwood. The medieval will also no longer required the institution of an heir. An heir had been the caput et fundamentum of a will in Roman times. The institution of the heir was essentially replaced by this disposition ad pias causas, or disposition pro anime remedio, for the benefit of the soul of the deceased. That meant that somebody had to be responsible for the administration and liquidation of the estate and for procuring the investment in heaven for the benefit of the soul of the deceased. In other words, there was the need for an executor, the executor testamenti or executor ultimae voluntatis. And the church was ideally placed to develop this institution. The testamentary executor has been called the creature and darling of the church, and that is certainly true. In Roman law, we only find very faint traces in Justinian's legislation, but not a fully developed institution of a testamentary executor. That was due to the church, and this development reached its apex in England. Heir was a term with a specific narrow meaning, only intestate succession in real property. Disputes in that regard went to the royal courts. The competence for testamentary matters lay with the ecclesiastical courts. Real property could not be the object of a will, and thus the ecclesiastical courts were limited in their jurisdiction to personal property. In that respect, however, they were completely free to apply canon law. There could be no heir concerning personal property, and so it was not unnatural to put the executor in his place, into the place of the heir. This entailed that the church could secure for itself the entire process of administering and liquidating the estate for its own benefit, but then also for the benefit of the soul of the deceased. Nullo herede instituto executor loco heredis est. Durantis, the famous medieval canonist, had stated, in Landward's Provinciale this became executores universalis loco heredes sunt. And Henry Swinburne, in a treatise to which I will come back later on the law of succession, wrote the executor who in the civil law is called heres. So this led to the rules once established by the Roman for the Roman heres being applied to the executor. The appointment of an executor was now, therefore, described as head and foundation of the testament, clearly alluding to Gaius 229, caput et fundamentum totius testamenti. The failure to make such an appointment did not, however, invalidate the will. An administrator was then chosen and installed by the church. The equation of the English executor and the Roman heres also manifested itself in the fact that the executor was the residual beneficiary. That means the person who kept what was left of the estate after the obligations had been discharged and the legacies had been satisfied. I'll pass over the splitting up of the estate in three parts and will come directly to the administration of intestate estates relating to personal property. Again, it was the church that took charge of this matter and of these cases. There's a question how often that occurred in medieval and early modern times. In Holdsworth we read, it was disgraceful to die without a will. Pollock and Maitland say there was an intense and holy horror of intestacy, but these are probably exaggerations. It was by no means uncommon to die intestate. And again, as I said, the church took charge of these cases. It was done for the good of the deceased soul in order that he would not suffer for his negligence or misfortune, for his negligence in failing to have drawn up a will, or his misfortune having died before he was able to draw a will, perhaps due to an accident. So the competent church official then appointed an administrator, and that administrator was chosen from those who had an economic interest in the estate, and these were the relatives. So the sequence of the administrator was determined by by the rules of intestacy. That meant that the church became comprehensively responsible for the administration of the deceased's personal property, whether the deceased had died testate or intestate. Let us briefly look at continental Europe. In continental Europe, we also find spiritual and secular courts side by side. We find disputes relating to the demarcation line between the competencies of these courts. The church claimed jurisdiction over wills because it was regarded as a causa spiritualis. On the continent, we find a thorough reception of Roman law, with the heir as the central feature in the administration of the estates, the concept of universal succession, as far as the heir is concerned. We also find, for example, from Roman law, the institution of mandatory family protection, the querela in officiosi testamenti, the actio ad supplendam legitimam, and so on. But we also find on the continent that Roman law was subject to influences and transformations emanating from canon law. For instance, as far as the form requirements are concerned, they were relaxed. And as far as the testamentary executor is concerned, the testamentary executor was introduced into the learned law on the continent, but there was always the difficult task now of coordinating the scope of application, the scope of power of the testamentary executor with that of the heir. And in the learned literature of the early modern times, Wolfgang Adam Lauterbach, we read, for instance, about the varietas et perplexitas of this institution, varied very much between different places in continental Europe, and that explains the different shape of the institution of the executor in our modern codifications. Back to England. Dispositions mortis causa concerning real property, as I've said, were prohibited by the royal courts. But that was a prohibition that was not destined to last. It could be circumvented by dispositions inter vivos, and one of these dispositions inter vivos was particularly popular, namely to transfer real property to a fiduciary. That was the origin of the institution of the use. The use was the precursor of the trust. And the use of the use, if I may put it like that, was very common by the 15th century. Eventually, Henry VIII, in 1540, enacted a statute of wills, which for the first time granted permission to dispose mortis causa over real property. The technical term in English law for such dispositions was to devise, and the form requirement was instituted, namely it had to be done in writing. And then there were the institutions of dower and courtesy. The surviving spouse received a mandatory usufructory right in real property of the deceased. So, if we look into the legal literature in England, we can take as a point of departure that even after 1540, different courts were competent to decide disputes concerning personal property and real property. The ecclesiastical courts on the one hand, the royal courts on the other. A will relating to personal property was to be authenticated by a personal representative in front of an ecclesiastical court, an executor, as long as the testator had appointed one in his will, or in cases of intestacy and administrator. So the nomen collectivum for executor and administrator was personal representative, personal because he was responsible for the personal property. No such authentication was required with regard to wills regarding to real property. The beneficiary stepped directly into the legal position of the deceased without the intercession of a representative. Obviously, problems could arise from that division of competences, but at least a stage of the development had been reached where a will could be made concerning the testator's entire property, whether personal or real. It is hardly surprising, therefore, that Henry Swinburne, whom I've mentioned already, devoted his treatise to dispositions mortis causa. That treatise was published in 1590 under the title A Brief Treatise of Testaments and Last Wills, and was the first work relating to the law of succession in the English language. It was prompted by the separation of the Church of England from the Roman Church, brought about by Henry VIII. That separation did not lead to the end of the ecclesiastical jurisdiction and also not of the law laid down by the ecclesiastical courts. Rather, the Roman canon law remained in force as far as it was not, I quote from the Act, contrariant or repugnant to the king's prerogative royal or the custom, laws or statutes of the realm. Swinburne aimed at presenting the law relating to dispositions mortis causa prevailing in England based on Roman law, canon law, and English statutory and customary law. Nearly a century later, another English civilian, John Godolphin, published a considerably more extensive treatise, also devoted in the first place to dispositions mortis causa, The Orphan's Legacy, or a testamentary abridgment. It consists of 3 parts: 1 of last wills and testaments, 2 of executors and administrators, and 3 of legacies and devices. Now, in part 2 you see of executors and administrators. Administrators means it also dealt with intestate succession. Conspicuously, neither Swinburne nor Godolphin conceptualize the rules discussed by them as being part and parcel of an overarching area of the law called the law of succession. One could say there was no law of succession. There were, in a way, 2 laws of succession. The same applies to Sir William Blackstone and his commentaries on the laws of England, the most influential book on English law of the early modern period. Blackstone deals with what we would regard as the law of succession in 3 different places of the second book. The second book is entitled Of the Rights of Things. That book discusses first the law of real property and then the law of personal property. In the first of these 2 parts, we find the 2 pertinent chapters 14 of title by descent and 23 of alienation by device. In the second of them, chapter 32 of title by testament and administration. That means chapter 14 treats intestacy relating to real property as a mode of acquisition. Chapter 23 deals with dispositions mortis causa relating to real property as a form of transfer. And chapter 32 deals with dispositions mortis causa as well as administration, which means intestate succession, relating to personal property as 2 methods of acquiring personal estates. In the continental tradition, too, the law of succession was for a long time not dealt with as an independent subject area on its own, but it was regarded as part and parcel of property. In the institutions both of Gaius and Justinian, that happened within the context of acquisition of property, with the acquisition of a man's property in its entirety per universitatem, following upon the various way of acquiring individual objects. that tradition was perpetuated until today by the Austrian Civil Code, which counts the law of succession among the real rights and conceptualizes it as an absolute right to acquire the entire estate or a certain part of it. In the ABGB, the Austrian Civil Code, you don't find a separate book on the law of succession. We then come to the Reform era, the Great Reform era, which played out differently in the different areas of the law. In contract law, I've mentioned that already, A.W.B. Simpson, innovation in 19th century contract law, based on Pendectist scholarship, predominantly from France and Germany. Family law, we've got the Matrimonial Causes Acts from 1857, 1923, 1937. And in the law of succession, this part, the sort of the last two-thirds of the 19th century, the first third of the 20th century, were a great era of reform. And that played out in 5 acts. First, the Wills Act, 1837. The same form requirements were introduced for wills concerning real and personal property. That means that was the witnessed will in its written variant, which has since then dominated all countries of the common law world. 2, the Court of Probate Act of 1857. That meant the end of the jurisdiction of the ecclesiastical courts. The jurisdiction was transferred first to the Court of Probate and then to the Probate, Divorce and Admiralty Division of the High Court of Justice. These were 3 areas of the law which were all shaped strongly by Roman canon civil law and the English civilians. One usually said probate, divorce and admiralty. That means that court is responsible for wills, wives and wrecks. Third, the Land Transfer Act 1897. The deceased real property was no longer directly vested in the heir or testamentary beneficiary, but in the personal representative. So the personal representative, responsible for the personal property, became, as a result of this act, also in a way a real property responsible for the administration of the deceased's real property. Fourth, the Administration of Estates Act of 1925, which overcame the distinction between personal property and real property. It was part of a comprehensive modernization of the English law of immovable property law. Concerning wills, one can say this act rolled out the rules traditionally applicable for personal property and based on canon law, rolled out these rules and made them applicable also for real property, because they were regarded as more modern and more suitable to modern times. No primogeniture, no preference for males over females, and so on and so on. Also, we now find the same rules on intestacy for real property and personal property. And then just to mention the 5th great act, the Inheritance Family Provision Act of 1938, so 101 years after the Reform era started. In the 19th century, dower and courtesy had been abolished, which meant that the testator was now completely free. This was the situation that prevailed in the early 20th century. Was found offensive by the courts. I quote from one court case, "A man may leave his virtuous wife and deserving children penniless and bestow the whole of his fortune upon the vilest companion of his profligacy, the most worthless partners of his vices, the most wicked accomplices of his crimes, and the law cannot gainsay him, even if he should openly flaunt his shocking disregard of all ties human and divine on the very face of his will. So the situation was remedied in 1938 by the family provision legislation, incidentally, that was a transplant from New Zealand. It had first been devised in 1900 in New Zealand and then transplanted to England. So we now come to the balance sheet, or a kind of summary. Of course, there have been reforms even after 1938. But essentially, the English succession law had found its modern shape as a result of the reform legislation between 1837 and 1938. Also, the basis had thus been created for relating English succession law in a meaningful manner to continental legal systems and for designing a comparative anatomy, so to speak, of the succession laws in Europe. The foundations of such an anatomy are the principle of universal succession. The estate passes, at least in principle, as a whole and at one and the same time to the successor or successors. And the two central issues that need to be dealt with by succession law: who is to get what from the estate, and how is who gets what, how is that implemented? The first of these questions is to be answered either according to the will of the deceased, which has to have been expressed by observing certain form requirements, or according to a set of rules provided by the law for cases where there is no such will, that is the case of intestacy. For answering the second question, the legal system has to make available rules on estate administration. One can refer to this as the allocation one can refer to this as the implementation as opposed to the allocation dimension of the law of succession. If we look at these elements more specifically, we can say the central instrument by means of which the testator expresses what he wants to happen with his estate after he has died is the testament or last will. And the will is a unilateral declaration that does not have to be communicated to anyone and that can at any time before the death of the testator be revoked. The rules on intestacy are intended to follow the presumed intention of a typical testator. The administration of the estate is undertaken by a person to whom the estate is transferred and who may also be a beneficiary who is responsible for administering the estate, paying the debts, paying out the legacies, and so on, but who is also the ultimate beneficiary. And in the continental legal systems, that is the heir. In English law, it is the personal representative. So, one must note the functional equivalent to the heir in the continental system is not the beneficiary, the ultimate beneficiary in English law, but the personal representative. The problems to be tackled by a system of succession law are the same both on this general level and with regard to more specific issues. The solutions, of course, can differ. Just to mention two or three examples, every legal system attempts to balance the moral precept of family solidarity with the principle of freedom of testation. It has, in other words, to provide certain rules on mandatory family protection. That can be done by either relying on fixed shares to be allocated to the closest members of the deceased family, compulsory portion, or forced heirship, or by establishing a needs-based system. English law, but not only English law, subscribes to the latter model. Other tensions to be resolved by every legal system are those between the intention of the testator and the way in which that intention has been expressed, i.e. between verba and voluntas testatoris, and between freedom of testation and public policy or the boni mores. The problem of how to implement the allocation of the estate can proceed from the idea that, at least in principle, the estate of the deceased is merged with that of the person responsible for the administration, or that it is kept separate. On all of these matters, and many other questions, a discourse about the experiences made in the various legal systems with one or the other solution is not only interesting and meaningful, but necessary for a critical assessment of the specific profile of one's own legal system. The process of change relating to what we know as English law of succession is also reflected in the more recent treatise or textbook literature, because it was only from the middle of the 19th century onwards that we really find books on the law of succession, that it was conceived as one area, one comprehensive area of the law, culminating in the first place in Holdsworth and Vickers, The Law of Succession, 1899. Modern textbooks carry the title Law of Succession as a matter of course. That corresponds to the German Erbrecht, to the Italian Successioni, but not to the French Droit de Succession. Strange and wondrous. That can hardly be said about the modern English law of succession. Of course, it has, like the law of succession in every legal system, certain characteristic features. They should provide food for reflection for the comparative lawyer. The English model of estate administration provides an excellent example from which we, for instance in Germany, can learn a lot. But all the elements constituting the history of the English law of succession were well known on the continent. That applies to the different treatment of movable and immovable property as much as the influence of the learned laws, or the rivalry between spiritual and secular courts. Some elements, particularly the customary ones, have shaped English law for a much longer period than the continental legal systems, with the exception, incidentally, of France and Spain. Others, such as the competences of the ecclesiastical courts, left a much more profound mark on the development of the law of succession in England than elsewhere. Some difficulties with which the lawyers of the continental jus commune had to battle did not present themselves in English law, or could be resolved more easily. That applies, for example, to the responsibility of the executor, or more general to the personal representative who administer the estate. On the continent, the executor always stood in somewhat uncomfortable competition to the person of the heir. All in all, therefore, the English law of succession does not appear to be a or the counterpart of the European, rectius, one should say, continental European laws of succession. It is genetically so closely related with them that it can be said to be an expression of a common European tradition. And if one wants to put this very pointedly, one can say the English law of succession is based on that other strand of the civilian tradition. Many of the continental systems, leave aside France here, many of the continental systems, Germany, Italy, are decisively shaped by Roman law. English law has been decisively shaped by canon law. Thank you very much.